All right, folks, thanks for being patient with us as we transferred over to a new Zoom link. This is in collaboration with our Coffee with the Coalition series that we do every third Tuesday of the month. Right now we have Carrie and Terry of ICADV doing a presentation on confidentiality in Indiana. We are going to give them the floor. Carrie is going to speak for a while, and Terry's going to answer some questions. So if you have any questions, just put them in the chat, and we will answer them as they come. And after we are finished with this presentation, I just want to let everybody know we're going back to the Zoom link that we started with. So each presentation, this is the only presentation that is going to use this Zoom link. Every other presentation that we have during the entire Core 40 is going to be the same Zoom link you used for the first session today. I will put that in the chat just so everybody is sure. So I will give the floor to you, ladies. Thank you.
Thank you. Good morning, everybody. Let's do a little self-introduction in case you don't know who we are. My name is Carrie Hyatt Bennett. My title is the Chief Legal Counsel at the Indiana Coalition Against Domestic Violence, and I've been here since 2005. And I'm also an adjunct professor of law at the IU McKinney School of Law in Indianapolis. Ms. Terry.
I am Terry Noon. I'm the Technical Assistance Coordinator, and I provide support to our domestic violence programs and our batterers intervention programs around the state. And I will be answering what I can in chat and throwing questions to our Chief Legal Counsel whenever it's crossing that line.
Terry knows every bit as much about this as I do. I can't do jack without her, so do not be fooled. So thanks everybody for being here. The reason I'm taking lead on this is because it's largely legal. Started out as a federal statute, and then it ended up moving into a state statute as well. So we're going to talk about the confidentiality obligations that we as direct service providers, or our programs as direct service providers, are obligated to follow, and what the exceptions are in those situations where there are exceptions. So again, I can't see much, so Terry, holler at me or interrupt me anytime you want to. So let's go back and talk about the historical infrastructure behind the confidentiality law. It all stems from the Violence Against Women's Act, which you probably know is current law and has been since 1996. Well, 1994 was when it was introduced. So 1994, one of the original authors of the Violence Against Women's Act, by the way, fun fact trivia, was our current president, Joe Biden. He was one of the initial authors of the Violence Against Women's Act. It was first authorized in 1994. It's been reauthorized several times since because the funding structure is set up that way. It has to be reauthorized every few years. It's been reauthorized consistently. The most recent reauthorization was 2022. So it is good law. It's federal law. And if you understand the supremacy clause, you understand that federal law, for the most part, trumps, no pun intended, state law. So it is. Yes, a pun is intended. No pun is intended. So it is still good law. And when it was reauthorized in 2005, one of the things that the Violence Against Women's Act really wanted to focus on was confidentiality, because we know that the survivors that we serve, couple of baseline points that we know as victim service providers. First of all, they are acutely aware of their own safety issues. They know their safety issues better than anybody. Okay, so number one here is they know how much danger they're in. So we have to trust survivors. Sometimes we get caught up in this, the survivor doesn't know what's in their best interest. That's bollocks, and that's a legal term. So the survivor does know what's in their best interest, and we have to trust survivors. We cannot release any of their information unless they ask us to and specifically authorize to, because they know how important confidentiality is to their own safety. So they recognize this on the federal level, and so when they reauthorized VAWA in 2005, they put in some very specific confidentiality provisions that we as direct service providers or our programs as direct service providers are obligated to follow. And not only did they tell us that we have to do this, they tied a bunch of stuff to it too. So a lot of our funding is baseline agreements, is conditional upon us following the confidentiality provisions in the Violence Against Women's Act. So the Violence Against Women's Act is a huge, it's almost like a federal civil rights act that's anti-violence. If you have any questions about VAWA in general, feel free to reach out to me privately in my email, because I not, you know, obviously this is my area of work here at the coalition, but it's also my area of academic focus. So I've done several probably unnecessary deep dives into the Violence Against Women's Act. So everything you want to know about VAWA, wow, am I fun at a party or what? So if anybody has any specific questions about it, let me know. There's lots of things that it does. It provides a lot of money. When you think about, if you think about the Federal Civil Rights Act of 1965, VAWA 1994 was akin to that, but sort of on an anti-violence basis. So it did all kinds of interesting things. It funded a separate set of grants to our prosecutors and to our local governments that are specifically designed to combat violence against women. It made interstate violations of some domestic violence laws federal offenses. It clarified things like the Full Faith and Credit Act, which means that if I get a protective order in Marion County, it's just as enforceable in Jennings County as it is in Marion County. And it's just as enforceable in Ohio as it is in Indiana. They cross county lines and cross state lines. So it did all kinds of interesting things to help this particular movement. But for the purposes of this training, what it really did is it tied a lot of those requirements to the universal grant conditions that we all agree to, right? So that's any sort of money that comes under VAWA. That includes VOCA, Victims of Crime Act money. That includes FIPSA, Family Violence Prevention and Services Act. And we're all funded in some capacity by FIPSA and have been since, I think, 1984. That was a Reagan administration creation. So a lot of our funding have these universal grant conditions that we are basically signing on to by accepting that. And one of those was the federal confidentiality laws under the Violence Against Women's Act. So it stems back to the reauthorization of VAWA in 2005. We, in turn, Indiana, adopted that same provision and codified it under our own Indiana law a year or two later. So now we have a specific Indiana code that references the federal law. So not only do we have to do this as part of the money from the feds, we also have to do this because it's part of Indiana law. So that particular statute in Indiana law is 3537-6. And what this actually does in a nutshell is it basically says we as victim service providers, that's a buzzword, we'll talk about that in a second. We as victim service providers cannot disclose any personally identifying information, another buzzword, about any of the survivors that we may or may not have served without a targeted release of information. And we'll get more into that release in just a second. But in other words, I can't share information about anyone that I'm working with anybody outside of this little organization that we're in now, not us, but ICADV and maybe a couple of people that I'm working with here. I can't share that information with you. I can't share it with the deputy prosecutor. I can't share it with the public defender. I can't share it with their civil counsel on their divorce case. I can't share it with anybody unless I have a signed, written, targeted release of information from that person. Even if we're on the same team, we still need a release of information. So I may be working closely with a survivor who's working with a prosecutor in Marion County, and she may say, hey, why don't you go ahead and tell the prosecutor that's working on this case? Like, actually, this happens quite a bit because I'm been around a while and I've taught at the law school for a while. So some of the deputy prosecutors in domestic violence court are former students of mine, right? So I have this survivor say, hey, my prosecutor's name is Annette, why don't you call her and tell her that, yada, yada, yada. And I'm like, I can't do that without a release of information from you. Okay, so we're all on the same team, but regardless of that, I still need her personally identifying or her specific release of information that allows me to share any information about her. It is at times a pain in the butt, but it's also required. So what can I say? This applies whether the information is being requested from anybody. DCS. If DCS wants information from us, they wield a lot of power, but we still need a release of information. We cannot confirm or deny. And Terry, you're on the ground, and I know you work with a lot of these cases. So if you want to throw any examples out here, just holler, okay?
I would, the only thing I would add to what you're saying is it has to be a release of information on our agency's letterhead, meaning our domestic violence programs or our sexual assault programs letterhead. It can't be DCS's release of information. And we have to make sure that they're not coerced in any way into signing that. So that's why it has to be our release. It can't be the release from a hospital or anyone else. We have to do our own.
Yeah. HIPAA releases are not the same thing as VAWA releases. VAWA releases are VAWA approved. It has to have specific wording in them. And what I tell people, because a lot of what I do is respond to subpoenas, Middleway House will be sent a subpoena because they want the files of somebody that they are working with. And it's so easy, and I totally understand why if a domestic violence or a sexual assault program gets a legal document, a subpoena or some kind of legal request for information, first thing you're going to do is kind of freak out, right? It's like, okay, this is a legal paper. What do I do with this? So my advice and what I tell our domestic violence programs is send it to me. Okay, don't respond to it. Don't deal with it. Just fax it to me, email it to me, because when you email it to me, then I can respond to the party that's requesting this information and explain to them what our parameters are legally. And I can do it in such a way that I don't confirm or deny that we've provided services to anybody like that. What I would say is, I don't know this person. I don't know if they've worked with them or not, but I do know that Middleway House can't tell you that.
I've seen some chatter about wanting to know what needs to be on a consent to release and what specific information that you could use for DCS, et cetera. I'm going to throw in the most recent VAWA compliant consent to release that you've sent out before. I'm going to be putting that in chat.
That's awesome. Thanks. And I can follow up with a PDF of the PowerPoint and all of these documents for your fun social reading. And we're only an email away. So holler at us if there's anything that you want more of a deep dive into. But Terry is absolutely right. And thank you for bringing that up, Terry, because what it can't be is it can't be a coerced release of information. It can't be, hey, sign this or we can't continue with your case, or sign all these documents and then we can offer you services. It can't be anything like that. That's why we want our domestic violence and sexual assault programs to take lead on working with the survivor, because it has to be per law, it has to be well informed. In other words, whoever's signing this understands the capacity and the scope of what this release does and does not do. So that's why we actually, the law requires that our programs help them execute that so they know exactly what they're doing. Personally identifying information. What is personally identifying information? It's really any identifying information about the individual, including, name, obviously, date of birth, social, location of the victim, address, zip code. It can also mean things like, the only Native American person in that small town. It can be It can be a reference to a racial or ethnic background. It can be anything that identifies them individually is precluded. And I'll talk about this in a second, but what can be shared, especially with our funders, because our funders always want to capture information about who we're working with. I know we all have to do those snazzy VOCA reports at the end of every quarter. So what we are capturing for VOCA is how many men, how many women, between the ages of X and X, how many were survivors of color, how many were survivors of different ethnic backgrounds. That kind of, you know, aggregate data is okay. But when it crosses that line into personally identifying information, that is not. Waivers. This is about the waiver, the release of information. They have very specific wording. We have drafts that you can adopt. What we do is we took the one from the feds and we put it into something that is VAWA approved. And then we made it such that you can brand that with your own letterhead, with your own logo or something like that. So all of our domestic violence programs, confidentiality waivers, basically, or release of information, they look generally alike, give or take a letterhead or a couple of things different, but they basically capture the same information. And to their credit, they went through a few years ago and made it much simpler. It's a much more, especially with COVID, because COVID, it was very different. It was very challenging to, to get these long written targeted releases of information when nobody was having face-to-face contact with anybody. So it's a simplified form. I think Terry just put it in the chat.
I'm struggling finding it, of course, right now, but it's going to be in there by the end of this. Just talk really slow.
Oh,
I'm teasing. Go on.
And we can always follow up with this and send it to them. We can, I want to make sure I send them the one that they can put their own like brand on, the letterhead, because we have several of these. We actually have a lot of paper on this issue. So here's the thing about the victim waiver or the release of information. Same thing. It has to be VAWA approved language. It has to be time sensitive. So you can't sign a release of information for the next 6 months. You can't say this is good for the next 6 months. It has to be targeted time of information. We usually suggest no more than 30 days, just to be on the safe side, because a lot happens with our survivors within those 30-day period. And we want to make sure that their release is still current when it comes time for somebody to try to, to use it or access that information. So it is time sensitive, targeted release of information. Targeted is really important because I really want survivors to be specific about the information they want to release. Especially, I'm a former prosecutor, been doing this a while. What I don't want is a general information that a survivor signs because she wants her victim advocate to testify about, X, which is good. The problem here is if it's not targeted, that's why I'm not a big fan of these anyway, but if it's not targeted release of information, then even though the victim advocate is going to talk about X, I don't know what the victim advocate's going to be asked on cross-examination. So we lose control over it if these are very sweeping waivers. So, and that's really a bad example because my preference is that victim advocates don't testify at all. Any kind of information that needs to be released doesn't need to be released through our programs, in my opinion. So these are time sensitive, focused, targeted release of information in writing, if possible. That's what's called informed consent. They need to completely understand what they're signing and why they're signing it. So sometimes I'll have people say, well, yeah, that she signed a release when, when she first got involved with this case. Well, what kind of release? I don't know. It was, one of those releases. I need to see the release. I can't tell you if it was what she needs to sign. Okay. So it's not a HIPAA release. It's not the same thing. So it's a very specific individual release. It must be signed by that person. It can't be signed for them. And consent may not be given if you're talking about somebody who's giving consent for somebody else. Consent cannot be given by somebody who is either suspected of or accused of being the perpetrator. Sounds like a no-brainer, but it really does happen. Okay. In the case of a deceased victim, confidentiality in Indiana, and this is different, this is different per state. Confidentiality in Indiana postdates death. In other words, even after somebody passes away, it's not a free-for-all on their information, which sadly we get sometimes as domestic violence, providers. If we have what we think is a domestic violence homicide, and the media approaches us and says, did you provide services to X? We cannot confirm or deny. That confidentiality stays with them post-death unless their next of kin signs a similar targeted release of information. And that next of kin cannot be the person that's accused of hurting them. Any questions, Terry?
I'm not seeing anything in chat. I finally found the limited release to throw in chat. So that's what's going on in chat. I would say that this comes up a lot because our domestic violence programs, at least, are reached out to a lot whenever there's been a death in the community to see if someone was seeking services, especially if they suspect it was a domestic violence death. And it's a time that our programs want to be able to assist law enforcement, but you still can't without getting the next of kin to sign that and release of information. So I think that's one of those that it's, when you talked earlier, Carrie, about it, that sometimes it's a pain and we want to be able to make things go smoother. It's still really important that the confidentiality as law follows in death, and we have to keep that.
Yeah. And this is why I want to stress because we're all trying to create community partnerships and work well with the people. We're all on the same side. Nobody likes violence, yada, yada. But sometimes you have to look at law enforcement and say, you can't come in. You cannot come into our shelter. You cannot do this. You cannot serve this subpoena. I don't care if you think she's here. I don't care if you saw her walk in the building 5 minutes ago. You can't come in here. And that's when I want you to engage, for lack of a better way of saying it. I was going to say me, but now I'm going to say Terry. That's when I want you to rely on this, because what we can do is approach this, because I don't know the survivor. I didn't provide services to the survivor, but I know the law. And so does Terry. And what we can do from that perspective is just say, no, this is what we have to do, and this is why we have to do it. It's not because we're not playing nice in the sandbox. It's not because we don't want to work with you. It's not always because we want to do this. We're doing this because we have to do this. And if you got a problem with that, then you talk to our lawyer, because that person is following the law. And that's why usually if somebody has a meeting with local law enforcement about subpoenas or requests for production or things like that, help us help you explain to them that we lack discretion in this area. We got to do what we got to do. And sometimes it's nice to go to, somebody like Terry or me, if you need to, just explaining that this is the policy. It's like this across the country. We didn't exactly reinvent the wheel here. You got a sexual assault program in Texas that law enforcement's trying to get information of, they're going to need a release of information too. Okay, so we didn't reinvent the wheel. We're just following the law. So I get a little chatty, don't I? Okay. What providers can share? What you can share, like I said before, is non-personally identifying aggregate information, like VOCA reports. You know, this is how many people we served this month. This is how many people we served last month. There were 47 women served. There were 14 men served. There were things like that. You can do that in an aggregate sense. How many women, men, you know, yada, 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 but not anything that's personally identifying information. There are a couple of exceptions to the confidentiality requirement. If the survivor files criminal charges,
Oh,
again,
hang on, Carrie.
oh,
There's
yep.
something, how would this work if a crime death would happen in a shelter or transitional housing program? It's the same.
It is. Yeah, go ahead, Terry. You want that one?
And that is really, really hard because we're already traumatized because that's happened in one of our facilities. And so you have staff trauma, other clients' trauma. You want to be able to solve it very quickly, but you still need to have consent to release of information. And that's hard. Again, reach out for support because that does happen. And it's hard, their personal belongings, everything, and what to do after the trauma.
Yeah, Terry's amazing, because when we have our meetings, I mean, she will crowdsource this. I mean, a lot of meetings, kind of like this one you're on, maybe, I don't know, it's my first one, but sometimes it's also just it's part substantive knowledge, but it's also part therapy, right? I mean, there's a lot of processing that happens with the work, and it helps to talk to another program who's been in the same situation, who's been through that same sort of trauma. And Terry is masterful at that, the best. So there are times where, like, I am not a stranger to unhappy people filing protection orders against me. So there have been times where people will file a lawsuit against the shelter, file or threaten criminal stuff. Unhappy people do all kinds of lash out sort of things. The protection of their information does not outlast something like that. In other words, there are exceptions to this confidentiality privilege. So some of them are criminal charges, civil lawsuits against programs, obviously the consent, the targeted release of information, and child abuse and neglect. That is we are all mandatory reporters of child abuse and neglect. So if we see child abuse or neglect, and Terry, I'll let you chime in here on this too, because this is such a nuanced area. If we believe there is child abuse and neglect, then we all are mandatory reporters. However, we want people to really think this through before they make a DCS call, in our case, outing a survivor. Because the unintended consequences of adding that to their already incredibly full plate can do more harm than good. If it's something that can be worked on internally, maybe parenting skills, parenting classes, something like that. Terry, you want to take that one because I know you've seen it more than I have.
I'm sorry, I was reading something in chat. So what am I taking?
Oh, not judging people because in your eyes they're not the greatest parents in the world, but it's still maybe not a DCS call.
If they're seeking services and the child isn't currently in danger, there's no DCS report to be made. We have conversations about parenting, giving them techniques. I think every parent in the nation has had less than stellar parenting moments, especially when they're under stress. And so taking that into account, and we all feel differently about spanking, discipline, etc. But to most people, would this be considered harmful and endangering a child? We need to make a report. One of the things I was reading in a private message is whenever you are working with an adult survivor of childhood sexual abuse, but now there's other children. So I'm just going to use an example of you're working with a survivor and they've said their father used to sexually abuse them when they were children, and now they are babysitting sometimes your own children, and worried about that he's perpetuating that with that child, and whether or not that would be a report. If the survivor discloses that, yes, I let my father babysit my children, I'm going to let you take that legally, but we certainly have a conversation with the client about the dangers, and the odds are that her father is perpetuating it with her children now. But we don't know anything's going on. So I don't see how we can make a report based on what, to me, that would be an opinion based on statistics, et cetera. So I think a well-founded opinion, but it's still just an opinion with no facts. So
Right.
I would be hesitant to disclose or to call DCS just based on information, based on that information. I guess if the survivor gave me more details and they were afraid to report, that would be a different story. But Carrie, give me your legal take on that.
So if I understand correctly, is it a child abuse or neglect reporting call if somebody that you know lets their father watch their children even though that person sexually assaulted his children?
Excuse me?
Yeah, okay. So I think I get what you mean.
Yeah.
Absent some sort of proof. I mean, absent some sort of, I mean, that's just making an assumption, right? I mean, we are an evidence-based system, right? So we're going to need some sort of evidence that that person is a victim of child abuse or neglect, not the fact that, well, that person was a perpetrator 20. I mean, I think our whole system is based on the idea that we give people the benefit of the doubt. So to me, that would be lacking in evidentiary proof. But perhaps that's the former prosecutor in me. But concerned about that. I just want people to understand the unintended consequences of making a DCS report that turns out to be unsubstantiated or turns out to be too quickly decided on. Because even, here's the thing, even making that DCS report, even filing what, a 310 or whatever, even that is creating
Carrie, I think you're freezing up, or I am.
Yeah, I think Carrie is freezing up right now.
Yeah, I turned off my video to see if it was me or her, but it does seem to be her. So
Okay.
she's saying all sorts of brilliant things, and I'm wondering if she's going to get kicked out.
Maybe the.
Well, while we're figuring Carrie out, I'm going to try to catch up in chat because oh. Everybody else here?
Yeah, we can all hear you pretty clearly. I think a lot of times when you're presenting and you have your screen up, it kind of causes connectivity issues. So hopefully we can get her back into the chat. Or I'm sorry, into the presentation. And maybe, oh, here she is. Just give us 1 second. Thanks for being patient, everyone.
Okay, can I get somebody from Tessa to go ahead and operate chat for us, and I'll share my screen so Gary can present and is an operating both.
Oh,
Yeah, I can watch the chat and I'll just interrupt when someone has a question, okay?
Okay, let me pull up presentation and I will share that. Carrie, I'm sure you were saying all sorts of brilliant things, but nobody had a clue what you were saying.
do you want me to get out of mine then? I'll get out of mine.
Yeah, and I am going to pull up the PowerPoint here and they're going to run chat for us.
Thank you. Sorry about that, everybody. We
Well,
do have
4 years into it, and it's still like it's so much easier this way. We just have technology glitches every now and then. So I'm going to find the slide where you were at, and we were talking about when to make reports.
I'll put some
Oh, I'm not sharing screen yet. I'm looking, I can see it fine, just so you know. Dear Lord.
I'll put some other interesting things in chat too, because we have I don't know if you guys are familiar with our confidentiality cards, but we'll show those to you in just a second. You know, Maria said you can always do a report to DCS anonymously, plus the report source will always be redacted if the abuse does not, I missed it. What I find that even if it's anonymous, what happens is sometimes you're going to turn around and get subpoenaed. Or sometimes you're going to turn around and be called on to present information and or evidence about that claim. So it would not be the first time one of our domestic violence or sexual assault programs received a subpoena on a DCS case where the original complaint, the original DCS call came from us or came from them. So in that case, you know, you can't make a call to DCS, then be given a subpoena and say, I can't confirm or deny. You've already compromised that person's confidentiality, so you have an obligation to continue that. So that's why it just needs to be really well thought out. Victim service provider under law is somebody whose primary mission is to provide services to victims of domestic violence, dating violence, sexual assault, or stalking. This is important because those victim advocates at the prosecutor's offices, those are not covered by confidentiality under VAWA. Okay, the victim advocates at a prosecutor's office, they are primarily law enforcement personnel. They are law enforcement employees. Their first obligation is going to be to that elected prosecutor. And I say that as a former prosecutor. So those victims advocates at the prosecutor's office do not have the same confidentiality obligation that a separate not-for-profit 501c3 primary services or domestic violence, dating violence, sexual assault, or stalking. Those are the ones that are covered by this, not others that call themselves victim advocates. And that includes the umbrella of DCS. That includes prosecutors' offices. Usually the victim service providers in sexual assault programs on campuses and things like that, they are covered by VAWA. But when in doubt, ask. It's all about where the money is for that particular position. If the money from that position comes from law enforcement money, or if it comes from
DCS contracts,
then that is not covered. And that's a
From in Indiana, it would be grants funneled through the Indiana Criminal Justice Institute, like FOCA, STOP, DVPT, any of those. If the salary is being paid by one of those funding sources, then they do fall under this definition, because that's the only way they can get those dollars.
Yeah.
I think you break that down a little bit more on the.
I do. I've got several different slides here with the actual statutory language in it. It talks about how Indiana law defines a victim. And it's a rather broad definition of victim. Not only does it include domestic or family violence, but sexual assault, dating violence, trafficking, stalking, who is not accused of committing the act of family or domestic violence or sexual trafficking or stalking. It also includes, it can be a member of that person's family. So that's a relatively broad definition that I threw in these. And again, I'll send the PDF. We will send the PDF of these PowerPoint slides if it helps. This is the statutory definition of victim advocate. And as you can see, it's a victim service provider or student advocate office of a state educational institution, like maybe a Title IX agency or something like that. The term does not include a law enforcement officer, an employee of a law enforcement officer, and that's what victim advocates at prosecutors' offices are. A prosecuting attorney or the employee of a prosecuting attorney's office. Not the same thing. And it's so important that the survivors understand where their information is confidential. It's more confidential at this victim service provider than it is at victim advocate at a prosecutor's office. The term includes an employee of victim service providers. This is important because it also includes volunteers. Okay, so anybody that's volunteering for your agency or for your coalition, they are covered by this confidentiality. Volunteers at a rape crisis center, as long as that agency or organization's primary purpose is to serve individuals that are victims of dating or sexual violence, human trafficking, stalking, that's their primary purpose. And that's, and again, that underscores the difference between a victim advocate covered under VAWA and Indiana law and someone that calls himself a victim advocate, but actually still works for an agency contracting with DCS or an agency contracting with a prosecutor's office.
If there's a fee for service, because all of our services for survivors, victims are free because we're totally grant funded.
These are our confidentiality cards. We have them, a box of them somewhere around here, but we actually have little cards like this. You can also print them out, get some, but it's nice for victim advocates to have this on them. And I have some of these in my wallet too. And here is the point. Not only does it remind you of these statutes, but as a victim advocate, you are not allowed to testify. So if you go to court, first of all, victim advocates do have the ability to go to court in any civil proceeding, or in any proceeding with someone that they are serving and sit with them. That's on this card as well. However, if someone tries to call the victim advocate as a witness, you are not allowed to testify. Then you need to turn around and what I tell our programs is you need to call my cell. You need to turn around and call somebody here at legal, so we can make the court aware of the fact that you cannot testify, you cannot confirm or deny. There is a certain testimonial privilege that comes with being a victim advocate. Sometimes I'll have lawyers that will ask for separation of witnesses as a way to get the victim advocate kicked out of the courtroom. Sly, but should not work, because if you can't testify, you're only there for support, then you're not a witness that needs to be separated. So lots of little nuances and things like that about confidentiality that we're happy to help with if we need to. think there's a back of a slide here too.
It would be great if I could advance it, but it won't advance.
Does that count for the advocate in the prosecutor's office? Hannah says. Hannah wants to know if an advocate in the prosecutor's office can testify. Hannah, feel free to unmic. I mean, this is pretty casual.
There we go. Finally advanced.
I'm not following the chat. Can somebody tell me what's going on? Chat. I'm going to move the chat up here.
It looks like, yeah, Hannah says, does that count for an advocate in the prosecutor's office? I don't know if she wants to elaborate more on that, or you all can elaborate more on that.
I can't imagine what a prosecutor's office victim advocate would testify about. But if someone is in the prosecutor's office and they get called to testify, are they allowed? That's up to the prosecutor. Prosecutor's victim advocate works for the prosecutor. If you were a victim advocate that worked for a DV program, I would get in the middle of that. How do I say that in a respectful way? Says partially funded by VOCA. Does VAWA confidentiality apply? Partially funded by VOCA. I would want to know more. Hate to be a tiny print person, but I need the tiny print. Don't you think, Terry?
Yeah, and the statute specifically says if you work for a prosecutor's office, you are not covered under the confidentiality.
Yeah, I kind of want to see
In Indiana, so that sounds like something's getting intermingled.
Not to mention that would be very, very complicated, because if you've got a prosecutor that expects their employee to do, X, and they're saying, I'm not doing X because I'm partially VOCA funded, that's just a little bit more than I think could be happening. Scott said, children cannot speak on their behalf. I have experience reporting to authorities, it being ignored, no doubt deferring to the adults in the convo. No offense to anyone, but I think we all have a responsibility to speak up for children. Absolutely. And we're all mandatory reporters of child abuse and neglect. We can report it, we just can't substantiate it on our own, right? So there's absolutely, if you believe that you have witnessed child abuse or neglect, but ultimately when it's investigated, there's just a difference between reporting it and being able to substantiate it.
Gary, can I jump in for a second? Are you able to hear me?
Jump away.
Okay,
Yep.
This is Kelly Gartland from ICASA
Hi,
HT.
Kelly.
I think that one of the questions that we sometimes get about the systems-based advocates and the community-based advocates is the different types of responsibilities that they can have, and that and I'll let you elaborate on this because I'm not an attorney, but while the community-based advocates are prohibited from sharing information, the systems-based advocates don't have the same, they're not prohibited in the same way. And so the question about whether or not they are allowed to testify is a kind of a separate question than the real limitation to do so for the community-based advocates.
Mm-hmm.
And so we sometimes see that when things get, either when there aren't community-based advocates in a community, or where systems-based advocates might be doing some things where best practice would be a community-based advocate. So going to the hospital, for example, after an assault. I don't know if that's the layer of Hannah's original question, because I know her mic isn't working. I wish we could let her elaborate more, but if that sheds any light, that is one of the,
I go back to the primary purpose thing. If the primary purpose of that organization is to provide services to survivors of sexual assault, domestic violence, etc., then to me that's very different than systems-based advocates. And I mean, I can't tell them what to do because I don't think they fall under our umbrella, which means they can't be predictable like the ones that fall under our umbrella.
Thank you.
So these snazzy little cards have the victim confidentiality statute on them. Our token phrase is, I can't confirm or deny that I've offered services to that person without a signed, written, targeted release of information. 99% of the time, if we get requests for information or subpoenas or something, they end up getting, you know, dismissed or dropped because we have a conversation with whoever the attorney is that is requesting that information, saying, you know, we can't do that, right? You know, and sometimes that's what it sort of takes. What's the next slide? Oh, this was challenged in the Indiana Supreme Court not long after we codified it under Indiana law. We had this was a Crisis Connection Southern Indiana domestic violence program. And there was a request for information about a client sent to them. And we ended up arguing it under VAWA confidentiality, state and federal, went to the Court of Appeals. Court of Appeals had a decision that we didn't think was a terminal decision, in the sense that it didn't really completely resolve the issue. We filed a motion to transfer, ended up in the Indiana Supreme Court. And the Indiana Supreme Court came back with a 5-0 opinion that said, no, this confidentiality obligation is real. It is mandatory. And with the overall understanding that if the information that a victim service provider receives from the clients in crisis that they're serving, if that is discoverable, if we can betray them and send that information elsewhere or share that information without their knowledge, blessing, approval, then people will stop seeking services, right? What does it mean? So that's really the brunt of the information, right? The argument here is we help them, we retain this information unless they want it to go somewhere else. You don't get to do discovery at our organization. I can send you this Supreme Court case if you want to. We were actually one of the first states in the country to have it challenged like that. So it's pretty good law.
We also have a question in the chat.
Oh.
It says, do you have any advice about convincing prosecutors of the importance of community advocates, particularly in the trafficking cases?
Am I thinking community advocates versus, you know, advocates as part of the system?
Yeah, Carrie, this is Karen. That was my question.
Yeah.
Trying to figure out, like, we're working with some SARTs on human trafficking protocol, and, you know, trying to impress on the prosecutors the importance of always connecting victims with a community advocate. But it seems like prosecutors would think, well, if they're connected with a community advocate versus just my advocate, I am likely to get less information with all the confidentiality. Like, how
it's a control thing.
Yeah. I don't know if they see it that way or not, but I always wonder if that's the case.
They see it that way.
Okay.
Yeah.
That was my imagination.
Former prosecutor. No, because if I'm a prosecutor, my victim advocate works for me. Right. If they start working with somebody at a program, then all of a sudden I lose control of the information. Victim advocates, and I don't mean this in a suspicious deep state sort of thing, but victim advocates in prosecutors' offices are law enforcement, entities. They work for a law enforcement agency. Prosecutor asks them a question about their discussion with that survivor, then they're going to answer it, because they have an obligation to the person that they're working for. Prosecutor asks somebody at a victim service provider about information about that client, and their response, and they know it, is going to be, I can't confirm or deny. Because we're not moles. Okay. We're not moles for DCS. We're not moles for the prosecutor's office. We're not moles for defense attorney. They don't get to use us to get information about a survivor. That's the point. So sorry.
That wasn't really the answer I was hoping for, but I figured that would be the case.
Well,
Thank you.
I mean, everybody, but we're all on the same side. If I hear that one more time, I'm going to barf in a trash can. Okay. So this was the holding in State versus Fromme. Basically, it said that the defendant was not entitled to inspect victim advocacy records. They were protected under the Violence Against Women's Act. More importantly, in this particular case, the defense attorney was doing sort of a fishing expedition, looking through the file to look for other things that could sort of blur the waters, right? So nothing like trying to find something about a victim of a crime also being a meth addict to try to blur the waters and turn it into some sort of victim blaming festival. So that's what this is, really designed to prevent. They're not going to get that information from us. This is what the limited release of information looks like, right, Terry?
Yes.
And it's super simple. It's just little boxes saying, this is what I want to release. This is why it's okay to release it. And this is, the effective time date. And it's as specific as possible. This is a weird slide because it looks like I was supposed to put a picture on there, but I never did. But I have a whole memo about, that needs to be deleted because that's the Court of Appeals decision. Why I put that in there, I don't know. This is the statutory definition of confidentiality communication, confidential communication under Indiana law. I'll send you the PDF of these slides. Hopefully they will be helpful. We have memos on how to respond to warrants. There's a difference between how our programs respond to, arrest warrants and search warrants, which, do I have time to go into that yet? I don't.
I was looking to see,
we're done.
Slides, so I'm gonna stop sharing.
But you probably have my email, but if you don't, I'll put it in the chat as soon as I put my glasses on. And if anybody has any follow-up questions, do not hesitate to reach out because this is a considerable chunk of what Terry and I do.
You guys have until 11:30.
Oh, hey.
We're just finished with the slide, so.
Oh, okay.
I think it's good to have questions too, but the difference between a search warrant and an arrest warrant, when you think about it, it makes sense. If somebody has an arrest warrant for somebody in a shelter, then, well, first of all, I'm always going to want to see the piece of paper. When in doubt, send me the piece of paper. If it's not signed by a judge, it's not a court order. A subpoena is usually not signed by a judge. So there's a lot of nuances here, but it's not as scary as it looks, I think is my takeaway on that. If it's signed by a judge, then you've got my attention. If it's a search warrant, well, either way, I'm going to want you to reach out to me. And I don't mean to take this on myself, but if you guys have a lawyer that you're working with or something like that, that's great. But I think it's important that they know, whether it's from me or whether it's from Terry or somebody on my legal team or somebody working with Terry, that we all have a general response to these. Terry, I'm going to let you talk for a minute. Apparently, I've lost my ability.
I want to know what other kind of questions that we missed in chat, because I can't look at chat whenever I'm sharing screen, or if anything has surfaced.
Yeah, what are you guys seeing?
I think we hit the questions that were in chat. I don't think there's any questions in the chat right now, but it does seem like people are engaged, so they might, come ask another question. So we're just giving them some time.
Yeah, no, that's fine. I'll go back to the warrant stuff for a second. Oh, go ahead, Terry.
I was just going to say, nobody minds getting out of meetings early, so we don't have to drag it out and give people time back in their lives. But I agree with giving it a couple of minutes just to make sure.
Yeah.
Go ahead, talk about your warrants.
It's amazing how quickly these will go away when you approach them with the legal argument that it's non-discretionary, right? So we get a lot of, if law enforcement goes to Coburn Place on a Saturday morning with a subpoena or something like that. I mean, they're not used to taking no for an answer. And that can be a very intimidating situation. But they need to know, we need to be able to convey to them that this is not our choice. This is not because we don't want to cooperate with law enforcement. It's not because of any of that. It's because that the people in that building have a privilege that we are not going to breach. We owe them an obligation to keep their information confidential unless one of 3 or 4 things is happening, and that subpoena is not one of them. We owe them the right to be left alone. So different policies, we talk about having different policies for things like subpoenas, requests for information, things like that. But don't let anybody make you feel like you're not playing nice in the sandbox just because you're upholding their obligation or their right to privacy.
Anything else from our sister coalition? It's your meeting.
I hope that made sense. Please feel free to follow up with questions or anything like that. Or if you have a specific scenario, just shoot us an email.
Okay, I guess if there's not any more questions today, I just want to thank you sorry, I look crazy, for your time today. We really appreciate this presentation. Oh,
I see Sarah Bent has a question.
okay. It
Ooh,
looks like
ICE agents. Okay. Hang on, I gotta put my glasses on. Yeah. Talk about power and control and intimidation.
But how cooperative should you be? Not like you can't confirm or deny.
Yeah. I think honestly, that's like one of the best things about having being able to blame somebody else, which would be, your lawyer, whoever that may be. Just say, hey, you're going to have to give us a few minutes. I can't respond to this because it's a legal document. Hang on and let me talk to our attorney. And
what's your extension, Carrie?
109.
Lord knows I'm not giving out mine.
What's your extension, Terry?
I'm extension 116.
116. Okay. Yeah. I was like, where's that damn paper? So yeah, I mean, okay. So ICE. Yeah, no. I mean, what are we talking about from ICE? Like a warrant? No, ICE is the same. That's not one of the, just because you're bigger, stronger, meaner, and carry firearms doesn't mean that that is a, that is not the same thing as a release of information. And take 10 minutes. If they can't take 10 minutes, something's up. I'm sorry, you're going to have to wait. I'm going to go discuss this with our general counsel. Or make up something like, we have 7 lawyers on our board and I'm going to go talk to them about this. Because we're not reinventing the wheel. Just remember that. We're not reinventing the wheel. It's like this with every domestic violence and sexual assault program in the country. Okay. So we're not reinventing the wheel. We're all, fighting the same battles. Don't be bullied.
There was an interesting point made in chat. It's not really a question, just a point made that it's harder in the military because of command and the, what you have to go through.
It is. It's a great, I mean, you know, talk about power.
Did you all see the question about in the military sometimes? Oh, this was the one. I'm sorry.
Yeah, it wasn't really a
That Terry.
statement of fact, and I can see how that would be really difficult. I would refer to one of the domestic violence or sexual assault programs not tied to the military for confidential services.
Yeah. All right. You guys reach out anytime, okay? Oh, wait a minute. Okay, every time I start. Okay.
Okay, go forth and conquer.
Thanks, everybody.
Thank you so much, ladies. Have a great day.
You bet.
Bye.
I'll send you the stuff.
All right. Thank you so much.
Bye.
All right, folks, we are about to go on lunch. I put information in the chat about what's coming next. We are going to go to lunch till 12:30. Please use the Zoom link that you used this morning for our very first presentation for the rest of the time with Core 40. We had coffee with the coalition that we did with ICADV. This last presentation on confidentiality, that was in collaboration with our Coffee with the Coalition series. So the Zoom link that you used this morning for the SART presentation with Alexis is the Zoom link you're going to be using for the rest of the time. I also put in the chat our agenda for today and the agenda for the rest of the week, and also the link to our presentations. If you have any questions, please send me an email. It's Mariah. I'm going to put it in the chat just so you can reference. If you have any questions, just send me an email and I will get back to you as soon as possible. I will see everybody back at 12:30. Have a great day.